So let me begin. Today was answer day, and today we filed 3 things which are available to you. One was the respondent's original answer, and the second one was the respondent's motion to secure separate property, and the third was the respondent's motion to dismiss for lack of subject matter jurisdiction. Daryl is going to go into them in more detail. Briefly, what they say is that we had to file an answer. That is just something we had to do legally to answer the things that they have sued Mrs. Araguz for. And we filed that, and we also filed a motion so that she can get back some of her separate property, which has been determined that belonged to her. But the third thing I think you're going to find the most interesting, and that's the motion to dismiss for lack of subject matter jurisdiction. Because one of the things that's swirled around now for the last 2 weeks are all kinds of allegations of fraud. All kinds of allegations of fraud that Thomas had no idea who Nikki was. Well, in the back of the defendant's motion to dismiss for lack of subject matter jurisdiction, you will find a affidavit that Nikki signed and submitted to the court, which goes into when they met and on what date she told him about who she was, and when they moved in together and how long they lived together before they ever went to the wedding ceremony. There's a lot of time involved there. You can draw your own conclusions as to who would know after that much time or who wouldn't know. Also, you will find a copy of an email between Thomas and Nikki on the day of her surgery, where he's sending her lots of love and other nice things. It's all there. Our answer is essentially this. The basic legal position of our law firm, Frye & Associates, representing the widow, Mrs. Nikki Araguz, is the following. The 1990 case of Littleton v. Prime has been overruled by operation of law. The 2009 Texas Family Code, Section 2.005, recognizes sex change for the purposes of marriage in Texas. That is our basic legal position.
Yeah.
Nikki, on the application for survivors' benefits on this pension plan, why did you put yourself down as spouse? Why don't you mark it as husband?
I don't know if he had anything to do with that, actually.
Here, I can answer that. He's listed as married at the top.
I
know she's listed as other. I don't know why, but I know from my own experience that it's very common sometimes whenever there are benefits and stuff like that for them just to go ahead and list as other, because they're named people, and then there's not a fight somewhere down the road in case they don't fit to a certain category. So the fact that he said married and then listed her as other, I don't really think is an anomaly of any kind. The main thing is that he listed her by name.
That helps your case, right? He did list her as other.
And married.
And all along we've been hearing he didn't have a will. Is this new that you've discovered this form, or you had that?
We knew all about it. It's just that it took us a while to get it. So this new law took effect September the 1st. So our argument, and it's delineated in our papers, is that
September 1st, 2009.
correct, that she had a legal informal marriage. When you hear the word informal, that's the new state law word for the old state law word, which was common law. She has a legal informal marriage since September the 2nd, 2009, up until the day her husband was taken.
Well, you may have already answered this, but you probably heard, I guess, Ms. Delgado's statements on Friday. When you hear the statements like, there's no way he could have known or anything like that, what does that do to you? What do you just want to tell them?
There's no way he could have known.
That's We don't need to go into that. They live
Well,
together for
No,
a year.
no, here, let
We'll
me
get
answer.
into that some tomorrow.
I actually want to answer that. There is,
Okay.
Kristen will address that also, however, but how it affects me, it saddens me for them because unfortunately they were not as close to him as I was for the last 3.5 years.
And a lot has been made of this case that perhaps it may be a test case for this kind of marriage. And, you know, it may go all the way up to the Supreme Court. Is that something you're willing to do?
You know, I'm willing to, with my team, take it as far as we need to protect the validity of my marriage.
And let me add this, it really shouldn't be a test case because the legislature spoke. One of the attachments to the motion to dismiss for lack of jurisdiction is the legislative history of this law that was enacted in the 2009 legislative session.
First few pages.
Yes, the first 2 pages, we just didn't copy the whole thing. You can get it on the internet. But it's the entire calendar. It shows who introduced the bill, when it was introduced, that it went through a House committee, that it was voted out of the House committee without opposition, and then a floor discussion, and it was amended, and when it was amended, they went from 4 categories to the current 19. If you read all these different categories, it's good government type stuff. And I know that one of the reporters is working on an article on this very bill and how it's passed. It'll probably pop up in the next day or 2. But it's all good government type stuff, those 19 issues. Okay, then the amendment was passed. It went for a 3rd reading. It went on the House consent calendar, which means uncontested. So it was uncontested, and it was voted unanimously on the uncontested docket. Warren Chisholm even voted for it. Then it went to the Senate. Wentworth had it with all the amended language. It went through a Senate committee hearing. It went through the whole schmeal in the Senate with the new language. There was nothing here. It was good government language. It was read several times to the Senate. It was voted, and it was voted without any dissent. All those record votes are there. So it was the legislative intent in passing this law and creating these 19 forms of identification that county clerks can look at with respect to issuing a marriage license. And one of those 19 includes for the first time in our legislative statutory code that sex change and proof of sex change can be used for the purposes of marriage. The statute in 2009 clearly trumps a case law from a lower level appellate court in 1999. It's just done. The legislature did it. So if anybody wants to appeal it, they're going to have to appeal a statute that the legislative history is very clear. They knew exactly what they were voting on, and that it was a good government bill. So we feel that the law is very much on our side. On September the 2nd, 2009, she and Thomas had a legal, informal marriage up until the day that he was taken from her in July of 2010. They did not have a same-sex marriage. So that's the way it is.
Phyllis?
Yes, ma'am.
Can you tell us, when do you do back and forth getting order? When are all parties scheduled?
We got to wait for everybody to file answers and stuff. There'll be depositions, there'll be discovery. But we want to make sure that Kristen has a chance to talk because Kristen knows some more about proof and evidence and witnesses that can help you with the allegations that have been made of fraud. Kristen? I think we're going to close, but I just want to make sure that everybody understands. And Deborah, I hope I didn't jump on you because that wasn't my intent. But this is not some big legal battle, first impression, all this other stuff.
I don't think you jumped on it.
Okay, good. Before the legislature spoke in 2009, make no doubt, this would have been an uphill battle. I've been developing for years and years and years all kinds of ways to discredit Littleton, and there are many ways to discredit Littleton. But then the legislature spoke, in the 2009 session, and the law became law on September the 1st of 2009. Littleton is a 1999 case out of the Fourth Appellate Court, Texas, which is in San Antonio. There are 14 appellate districts throughout the state. So this is a 10-year-old case by one intermediate appellate court down in San Antonio dealing with conditions that were the way they were in 1999. The legislature in 2010 said sex change can now be used for the purposes of marriage. Littleton just is not even relevant anymore by operation of statute.
But is that grandfathered law, the fact that the marriage occurred prior to change in the law? Does that, in other words?
There you go. Well, that's a good question. That's a very good question. That's why we have put into our pages that you have in our answer that beginning on September the 2nd of 2009, she and Thomas met the 3 conditions of an informal marriage. And these are statutory conditions. One is that they made an agreement to be married. Okay, any couple that is in love, as they were, and that live together as they did, they make that agreement almost every day. That they are going to be married and remain married. And she and Thomas made that agreement all the time. Okay, so that's one. Second is they have to live together in the state of Texas. They clearly did. The third is that they have to continue to hold themselves out as being a married couple. And from September 2nd, 2009, to their bankers, to their neighbors, to their friends, to their church, to their mechanic, to everybody that we've listed in our papers, they held themselves out. So there is no doubt that from September the 2nd, 2009, they had a legal, informal marriage until the day he was taken. So that's it.
Could I ask you one thing? It just occurred to me. That
Yes, ma'am.
This is probably, for Nikki, this is probably the 1-month anniversary of everything going on. I mean, is it getting any easier? Is it more difficult? Is this just a living nightmare?
It is a living nightmare, and it's not getting any easier. No. Every day I miss my best friend and my husband, and it doesn't make it any easier. We should have embraced it. Our entire family should have embraced each other, and the loss of my husband, a son, a father, and that's all I have to say.
There should have been family healing.
Tomorrow,
yes.
Tomorrow we will get into talking about Heather Delgado, the kids, all of those kinds of things. Not today.
I won't be discussing that.
Yeah, and you'll get to meet Carolyn Boston.
Will that be here in a little bit?
Yes. So, I think we pretty well settled the legal issue, and I think we've taken a good slap at the fraud issue. Part B will be tomorrow. And we appreciate y'all coming here. You're more than welcome to visit with, like I said, there's a lot of transgender people here. There's a lot of political and religious leaders from the community here. And I know they'd be glad to chat with you. We have refreshments. The center went to great lengths to make sure that there was some sweet rolls for all of us who don't need another sweet roll, but they're there. So thank you very much.